All right, hello Professionally Integrated, thank you so much. I have a really great attorney here who plays a big part in my life before he really got into the trial attorney that it is now. For all of you, this is Tyrone Glover. Tyrone Glover was an instructor of mine in jiu-jitsu. He was already a black belt in 2005. I think I may have been a white belt, maybe a beginning blue belt.
Maybe one of those like white belts with the blue stripe that goes around.
Yeah, that's probably what it was. So, which is true. You got to start somewhere.
Yeah.
So this is a great segue because Tyrone, he's a fighter. He was Paragon's first black belt in jiu-jitsu. He fought in MMA and in Pride, undefeated, has not lost. He's humble here. And with that, he also takes that same passion and fighting into the courtroom for patients that are injured. So we're going to start a little bit one, thanks so much for being here. Thank you for being a huge influence and role model in my jiu-jitsu career and for killing me. And I always tell this one story. You are one of the most ferocious but also physically gifted fighters. And I tell this story. I was telling my cameraman Joey here, and I told you recently. There was 7 of us watching Tyrone show us a move, and his physical abilities, he showed a move where he was balancing his whole body on one arm while talking to us, and we all looked at each other and we're like, dude, we can't do that. So he has some amazing abilities both on the mat and of course in the courtroom, and you've had some amazing success as a lawyer. Before getting into personal injury, let's talk, unless you want to fill in a little more with your fighting career.
Just that, thinking back to that day and me being on one arm like that, I don't know. I feel all sorts of aches and pains just even thinking about that. And yeah, just hopefully this is going to be good for your audience because we've known each other for so long. I might be spilling a little more tea than I normally do. So
that's good.
Yeah.
That's good. That's what we want. That's what we want. But with that, before you got into personal injury, you fought for civil rights.
Yep.
So can you talk to us a little bit about that, and also just with your area of specialty and with all the docs that we talk to here where they may work with attorneys in personal injury, and those lawyers in 20 years have never been in a courtroom. And I'm not saying that that's the right thing or that's the bad thing, but man, how many times have you been in court? And I think that's a huge benefit for my patient. It is a huge benefit for my patients. Talk to us a little bit about your civil rights, some cases, and how your past as a fighter and how that's molded you to help fight for my patient and the docs that are watching their patients.
Yeah, no, absolutely. I remember, because I think initially when I graduated law school, I had been clerking for a great firm, and I was going to go into doing mergers and acquisitions and corporate stuff. But one of my mentors in trial advocacy was like, Tyrone, you're never going to get the same rush, the same sort of competitive spark unless you're in a courtroom trying cases to juries. And so I found myself a few months into my job. I love the people that I was working with, but I missed the courtroom. And so then I was able to kind of jump ship, and they took me back at the public defender's office. And I think I tried 4 cases in the first month because, they try to kind of test you to see, what you're made of. And I was like, I'll tee all of these up for trial. 4 cases in the first month, 4 not guilties, and then after that we were kind of off to the races. I think I picked a homicide jury, which is the highest case that you can do as a public defender in the first 9 months that I was in the office. And gosh, I can't even tell you, it's been dozens of jury trials, in my career. But the thing that I love about trial work, and I think there's some really cool parallels to fighting, is your ability as a trial lawyer. It's it's a tool. It's like your martial art. It's a certain set of skills that you can apply to a bunch of different areas of law. We were just talking about basketball before we started filming, but one of my mentors, Pamela Mackey, who represented Kobe Bryant, she used to always tell me, it's like, look, we can get up to speed on the material. It's going in there and that skill set that you've developed and cultivated throughout your career to be able to actually fight, to sort of know how to cross, to know how to pick a jury, to be able to pick up on the themes as they're happening, right? I've tried cases against some of these really big law firms, right? Or the law firms that are funded by a lot of insurance money, and they come in so well rehearsed. They've done a script. They've done so many mocks, and they've got it perfect, and they've got their crosses memorized, and a week or two in a trial, they're still trying the case that they thought they were going to try.
Right.
And we're trying the case that actually happened. And we're ebbing and flowing, and we're improvising, and we're referencing stuff that happened, in front of the jury. And that's like the sort of dynamic, dance that is fighting, right? It's like you think it's going to go one way, and by round 5 or 6, no, that's not how it's going. Yeah.
And then you have, and again, I think this is another great topic. They're relying on scripts.
Yeah.
And you're relying on knowledge and experience. And man, what I say is, I'm not against people. I know there's docs that are taught scripts, but you're right. Having a script, and I said this, having a script to sell your care on our side is good in the shallow end.
Right.
But then once you start to get dragged in the deep end, which happens every other patient, you have to know the evidence. You have to know all the different moves, right? Like, and I think that is a great parallel to martial arts. Like, hey, you might know a really good Kimura from side control, but if you're now in guard, what are you going to do?
Right.
And you have that great script. So yeah, I mean, that's so are you saying that you got into the court for the thrill because you like thrills? That's
I like thrills. I like the I like
the adrenaline.
I like the adrenaline. Like I literally, like, people who know me will see certain mannerisms come out from the fighting days when I'm like getting ready to pick the jury. Like I start kind of, I mean, you hate that. Yeah, you see me crack my neck, but I'm cracking my knuckles. I'm doing the things, shaking out, like, ready to go, right? Like, it's the same sort of adrenaline rush. And it's the same sort of concept, right? Like, if I go into a fight, I'm not like, okay, I'm going to throw a jab, fall by a cross, then I'm going to duck in, and that's what I'm going to do. And if that doesn't happen,
what do you do?
No, I'm going to go in. My shot is going to be cold. I'm going to have practiced that shot probably hundreds of times. I'm going to have thrown probably thousands of punches, and I'm going to be ready for anything. And yeah, maybe I'm going to come out with sort of plan A, but I'm not even going to have to think about plan B, because the second then something changes, it's so ingrained, you just react, right?
You're comfortable.
Right. So like lawyers, witnesses, if you go in, if you know your facts cold, if you know the evidence cold, you know the science cold, right? Mm-hmm. Then you can ebb, you can flow, you can adapt, right? You can answer, and one of the things I've realized in some of these PI cases, especially if you try them in like metro areas or Denver, anywhere in Colorado, you get such an educated population. You'll end up with like 20 jury questions afterwards.
Right.
And the docs that can't go off script struggle with those. But the ones that, they can pick up on what the jury was sort of where maybe they needed a little more educating, or maybe they have some doubts, or maybe some witness that they didn't even get to see testify talked about something different, right? So the folks that are really, I think, go in there with the skills dialed in are the best witnesses.
Let's talk first what you hate to see from doctors' notes. For someone that we know is hurt, they're hurt, but what is the one thing that that you don't like to see, that needs to be better on, not everyone, but some, like, hey, here's notes.
All right.
Talk to us a little bit about that, how that can affect you from representing and protecting the patient's needs and care that they should be getting, so that you aren't teed up to go to court. What can prevent that from you?
Well, I want to see good, thorough, accurate, consistent note taking from day one.
Yeah. Right?
Like, you kind of live and die by the record when you're actually trying a case. And it's not the sexy stuff, right?
Right.
It's like there's a story I think I've heard about. I remember when I think Floyd Mayweather, it was like the night before like a training camp, and he said, what? Camp started, and he just sort of left the party that he was at and just started, doing road work, right?
Yep.
That's not the sexy stuff. Running 6 miles at a jogging pace, I used to train with Jocko Willink, him being in the gym every single day at 5:30 doing the same kind of weight routines. Not the sexy stuff, but it's the stuff that ends up being your armor and your sword.
The foundation.
The foundational stuff. So having good note-taking, thorough, accurate, intentional notes from the beginning, right? The thing that I hate is like if you have this really scant notes or even little one-off sort of scribbled things with no follow-up, and then we get close to trial and like expert disclosures are due and all that kind of stuff. And now you have this big, thorough narrative, right? When I'm crossing a witness like that, like if I'm crossing a defense doc or, I'm eat them alive. If suddenly when we're in a litigation trial posture, now they have all of this detail, all of this stuff,
Right.
And don't let me find like a note from a couple of years earlier where there's just like a little one-off, right? And then they don't even follow up on it.
Right.
Like you're just going to exploit that. So I think just good, thorough note taking from the very beginning. Not using kind of block copied scripts.
Just a small macro. Right.
Yeah, just good. But good,
you don't want that,
accurate, solid. You don't. It's hard to see, I think, in the PI world because you don't know which doctors are. There's not like a class of doctors that are doing the notes well and a class that aren't doing it well. Like it sort of varies by the individual. But where I kind of cut my teeth in the criminal world, you can very much see it. So when I'm like doing municipal cases, when I'm doing state cases, and I'm dealing with local cops, you can run circles around the lack of sort of report writing, right? But then, flash forward, I'm doing federal cases. I'm dealing with ATF, I'm dealing with FBI, I'm dealing with DEA, and their notes are ironclad from day one.
Now, what... in terms of a personal injury, I'll give you my perception of what we've talked about and what's on the site. We always, from day one, I understand, and I do believe, the insurance company, the patient, has a right to ask questions, right? I want to answer those questions so they don't even have to ask them. So when you get them, they're like, hey, you have in your notes here their head position. You correlated head position to how that can increase the likelihood of a crash right from the beginning. You mentioned that they don't just have neck pain, they have neck pain due to this type of injury. Do you like to see, is that what you consider ironclad, where you're like, hey, the objective findings linked to the research, linked to their subjective findings, and then you're showing a form of improvement, and then even objectively? And then when you don't have that from providers, what do you do?
When you don't have it, then you're sort of having to come up with strategies to kind of work around it and explain it away, right? I have this concept called kind of run to the bummer. If you have bad facts in your case, bring them out in your case in chief. Don't let the jury hear them, for the first time, right? But, having that sort of, I think it's like, I like to call it like the compassionate, objective truth seeker, right? So you want to make sure, you're a treater. So you obviously want to show that you're different than, say, like a defense doc that's just coming in and doing a note review, right? So that sort of patient care needs to come across in your notes, right? Which is why I think the sort of block copying of stuff doesn't show that. It needs to be objective, right? So you have to tie it back to evidence-based science, right? It needs to be grounded in studies. If there's stuff where there's maybe a difference of opinion, right? I mean, even addressing that in your notes and explaining sort of why you're taking a certain approach versus another one, right? And not just sort of for the first time dealing with it on like your rebuttal expert, a report. And then, I just think not coming across as an advocate either. Being like, look, this is what the science shows, right? 100%. And I want my patient to get better. I'm evidence-based, I'm science-based, and so this is the approach that we're taking. If it's a close call, you document why you went the way that you went, and it's documented from day one. Kind of back to, you be the FBI agent, right? Have it well documented on the front end, right? And have it be consistent throughout.
So let's go back to the run to the bummer. Is that what you said? Yeah. Can you give us in your experience, whether it be civil case, criminal case, or a personal injury case, can you give us a couple examples? Let's see if there's some PI where you're like, that's not good, and they didn't address. It's not that bad, but they're making it look not very good. And what could have been done to explain it from the get-go?
Right.
Do you have any examples of that?
So, for instance, if someone has, say, like a previous accident or a previous fall or something, or a crash or something like that, right?
That they were hurt.
That they were hurt. Right. And just, instead of kind of downplaying that or ignoring that in your notes, put it there, put it front and center, and explain thoroughly and consistently as early as detected, day one, why you are maybe not factoring it in your diagnosis and why the evidence would support the direction that you're ultimately going.
Right.
So when you get on cross and they're like, oh, so did you know in 20, it's like, actually, yes, I do. And if you look at my 2012 note from blah, 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 I've addressed that here. I felt, in some cases it would be a factor. In this case, because this and this and this and this were presenting, I felt as though, we did some additional diagnostics, and I felt comfortable that, this was not the root cause, right? And then if it's like, oh man, before we're even teeing this up for trial, before demand, before any of it, you're already thinking about it, right? It's just so hard to pin down a witness that has taken good notes, that has a good record, that has a good report from day one.
Why do you think, and everyone has a different opinion on this, why do you think that the insurance companies, no matter how good some of this is, why do you think they always, I don't want to say always, but they will fight a lot of patients being hurt in crashes?
I think that, insurance companies, they do kind of a cost-benefit analysis, right? It's very much business, and that was kind of where I saw almost like a social justice calling to do PI work, was when I kind of realized, like, whoa, okay, the same sort of fights that I'm fighting when we're going up against the government, when we're going up against big corporations who are discriminating against their employees, the same thing, the sort of David and Goliath is playing out with these insurance companies who are like, you're really, really hurt? Yeah, we think that we could probably get you to take less, and we can pay some lawyer, $50,000 to get this through discovery, and we can offer you this chunk of change, and you'll probably take it, right? And it's just a very sort of, I think, economic calculus, right? So I think that's really, they kind of have their formulas, in the back rooms, and they kind of live and die by their formulas.
Well, I think a lot of those formulas too is a big part where I've always said this. I think insurance companies, from my perspective and the amount of times I've been to court, I think that they're not very educated on the injuries, or they pretend not to be, but they're incredibly educated on business.
Yeah.
And part of that business is they're going to look at this guy, and they're going to look at me, and they're going to be like, does that guy fight? Does that guy, is this doc educated and documented correctly? What's the history? And they do that. They track you. They track me. They track the docs that you're watching. And if you are working with a lot of lawyers that they just have never stepped foot in a courtroom because every case is settled and you've accepted every settled case, guess what they're going to do? Yeah. They're going to offer less and less each time.
Right.
And that's
a lawyer that does does a high volume and settles everything. It's like, okay, yeah, no, we have a large enough sample size to know exactly what you're going to do. And if what you're going to do is not go to court,
we're going to just offer you 5% less than we did last year. Yeah. And then next thing you know, they're going to pass that on to the docs to take even less. And then the patient leaves with chronic pain, their bills are not covered, and they don't have enough to get future care. Yeah. So what do you, when you fight for future care also, right? So one of the goals, a lot of the goals with the profession integrated, one of them is, these are the pathologies, here's the research and the science that suggests that this could lead to worse problems. Right. Like, I don't know, I know you very well, and I've had, been able to help you with other things, but before you were just joking, like, oh, my shoulder. Right. If you were still a fighter, and even it doesn't matter you're not, and you got injured and you couldn't fight anymore, and the likelihood that shoulder was going to bother you forever, right, how important is that to put in our notes about the long-term complications of that injury? Yeah. And then what do you do about that for the long-term consequences? How do you add in to fight for it? So, because a lot of attorneys, they settle for not even enough for the care here. Right. And then you're like, well, what happens to the long-term care? So what's your take on that?
Yeah, I feel like I almost focus more on the future. Okay. Like, I think, the sort of, and I think it's partially like, it's my background as a civil rights lawyer, mm-hmm, right? It's not so much compensating them for what happened then in that moment. It's how this moment in time, and probably the most tragic thing they've ever experienced, is going to resonate and affect them for the rest of their lives. And but for what happened, they wouldn't be dealing with this, right? And that's really, in my view, justice. It's keeping people the best that you possibly can, restoring that trajectory that they would have had but for someone else's negligence. Right. So, if somebody had all of these, ambitions to go out and, have this fulfilling career where they're crisscrossing the globe, and they were teeing themselves up to do that and getting the education and getting the job experience, and then suddenly they're hurt and they can't do that anymore because they can't sit on an airplane. Right. I just think, like, jurors really resonate with that lost opportunity.
Right.
The freedom to be able to go out and live your life the way that you've envisioned and dreamt of since you were like a child in many cases, right? And you've done all this work, you've sacrificed, and now because of someone's negligence and because of an insurance company's stubbornness, you potentially are going to lose all of that. And so, yeah, my focus, rightly or wrongly, is really how this event has affected their trajectory.
Right.
You of course want people to be compensated for what they've paid out and sort of their pain and suffering up to that point. But really, it's about the lost opportunity of the future that they once had the ability to live out.
So, and that's all incredibly powerful. So how do we as providers, we know it, how do we, and I know how I do, I just want to hear for you to tell everyone, how do we give you that with our clients to show that?
Yeah, take the extra time when you're doing your patient intake to really get to know them, to get to know what sort of drives them, what they like to do for fun, what they like to do for work, how, whether they have kids or grandkids, where their grandkids live, where they, really take that extra time to get to know your patient on a human level, understand what their hopes and dreams are. And then, knowing the injury, make sure you document how that injury may affect, their ability to live out those hopes and those dreams and those goals, and do it from day one.
From day one.
Right.
So remember, all docs on the site, go to a pathology. There's a box that comes up with causation, chronic, neurovascular. Click on chronic, and there's tons of research, journal neurosurgery, things that we know that if that pathology is present, and especially symptomatic, what the chronic outcomes could be, and make sure that's in the notes. Like, why can't this person bump ski anymore? Or why does it hurt for them to breastfeed? Well, because in flexion they have instability and they have a kyphosis, and here's the long-term consequence of how that causes tissue damage. And that's the things we put in our notes to be like, hey, this person is hurt. And then Tyrone can literally say, this was already documented. Day one, and then maybe in 3 months you're treating the patient and you're like, hey, I was feeling pretty good, and then I went and I, tried a berimbolo in jiu-jitsu, right?
Yeah.
Which try to stay away from with your neck.
No one over the age of 35.
Yeah, and then their neck goes into flexion and like my neck flares up.
Right.
And you're like, that was already documented. You've already documented how that pathology causes a weakness. And if that trauma from the crash didn't occur, they were doing berimbolos before, it explains why, right? Like, so that has to be in there from day one.
Yep.
Do you, with all your civil rights, like, and standing up for people's rights, I know how I feel, and I don't think I've talked to you about this. Do you feel that, like, what the insurance companies do to injured people is almost an infringement on their rights?
I mean,
does it go that far? And I'm not saying like they have the right to do it, but does it get to your core like that with what you've done? And you see this, like, dude, it's so well established, and they find all these other scripts to not address the problem. Does that resonate with you in that way? Or
no, it absolutely does.
Okay.
And when you say civil rights, like, oftentimes in the context of litigation, you're talking about litigating under very specific sections, right? Like 1983, 1985, Section 1982, Title VII, right? Those are like the civil rights sections.
Okay.
But I sort of take a broader sort of umbrella approach to it, because I think anytime an individual has suffered an injustice, from the hands or on the end of power, right? Where there's a huge power imbalance, whether that be their employer, their local government and the police force, whether that be the insurance company who is supposed to be making sure that folks are made whole and indemnified and taken care of. Sometimes it's even their own insurance company.
Right.
Sometimes it's a school, right? When you have this huge power imbalance and the person in power is exploiting their sort of and using that as leverage. To me, that's a sort of civil rights kind of issue, right? Like you're not necessarily violating someone's rights, but there is a social injustice that is occurring.
I'm not saying they're bad people. I'm not.
No.
But it is a big, like, like you're a lawyer and you fought for this, and there is an injustice. Why are some lawyers not seeing that injustice and just settling these people that their quality of life and their joy of life is diminished? What's happening there on our end too with providers that are in this? Like, how do we change that?
Yeah, I mean, I think, some, just like probably in medicine, right? Like, some practices are probably run more like businesses than they are sort of like, like my dad's a doctor. I've sort of grown up sort of seeing, a sort of compassionate level of care for patients. But, there are some law firms, I think, that see, their ultimate goal as more like, they're more like CEOs of a company. And at the end of the day, making the numbers work, right? And getting enough of these cases settled, they're doing the same calculations on their end, but from the plaintiff side as like the insurance companies. Right. And then also I think some shops are not, they're not working up the case to go to trial, right? Mm-hmm. My philosophy is, if you got a case that's ready to go to trial, that's a case that can settle at any point, right? So, you do the right things on the outset. Your notes are good. You've done good research and diligence on, exactly how you're going to do like written discovery, who you're going to depose, which experts you're going to retain. Like, I'm doing all of that to be able to try the case, right? And if along the way it settles, like there's obviously like good points to sort of discuss settlement, great. But if it doesn't, like we're on the trial track, and having done criminal defense and being sort of opposite of really good prosecutors, like I know the feel of like somebody on the prosecution end, right, the plaintiff end, that is really effective, right? It's not the person that's doing a whole bunch of busy work to just kind of, churn the case in the beginning. It's the person will be cool, calm, and collected, come trial day, and will try a case, try like a homicide in a week and have it just like dialed in. And you're like, that's the person you're afraid of, because it's like, if we don't plead this out, if we don't settle this, it's going to a jury, and who knows what they're going to do. So I think, there's a lot of lawyers who are great at doing discovery, right? They're great at sort of getting in there, corralling their experts, doing some depots, beating up the other side, and then hopefully settling. But if you can kind of trim the fat off of that and just get through discovery and get into trial posture, I feel like a lot of times that's when, people start to show their true colors.
When you're starting, say I'm treating a patient, you're representing the patient, and we're like, hey, everything is well documented and we're getting ready to go to trial. How often do you reach out to some of the treating providers to ask questions, to help them educate you if you have a question? Is that something common you do?
Oh yeah, very often.
And the reason I ask that is there are some docs that have contacted me a bunch, and they're like, this lawyer has never even reached out. What can we do if there is, and you're not speaking for everyone, and you do reach out, are you comfortable with docs also calling you to say, hey, I just want to fill you in? How do you feel about that?
No, I think that's great. When you are juggling all of the balls, right, and you have you're spinning plates, right, trying to get ready to go to trial, right, and if the defense is doing a good job, they're keeping you busy with a bunch of stuff, right? So having that doc reach out and be like, hey, would love to get on your calendar just to kind of discuss my testimony or discuss my report or just a thought on this or on that. Like, that's a little tickler like that, I think is much appreciated, especially when you're kind of in the throes of battle, because there may be something, a particular issue that you're so fixated on that you're trying to sort of get over the hump on, right? And then you get over that and you go, okay, I can finally breathe. Then you're like, oh shoot, I haven't talked to Katz about that thing, blah, blah, blah. But if you've already been pinging me and I'm like, oh, we're scheduled to talk, tomorrow, after this hearing, then, that, I think to me, that's really helpful. It helps me sort of, because it's a team effort, right?
Right.
And, if as like the sort of point person, team captain, having the sort of supporting folks in the team make sure that you're looped in on what's going on is immensely helpful.
Do you like, is it helpful if just even patient comes in, we send them to you, you get this patient, and we don't even wait, we just send you a quick synopsis, like, Dear Tyrone, we're treating patient X. Patient X has been in our office. They were involved in a car crash. They were diagnosed with A, B, and C. Just a real quick little brief letter to explain what their injuries are. Is that helpful?
Potentially. I mean, you might not want to do it too early, right, in the process, because you don't. I think if you are like, look, I've seen this. I think you may want to consider talking to a lawyer. Blah 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 blah. Before they've even signed up with a lawyer. You don't want to think about But if they've signed up, they're like, I feel comfortable with them, and then maybe the next time you see the patient, they're like, yeah, so I have so and so on board, and we're. He said to keep treating and this and that. I'm going to keep coming to you and blah, 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 blah. Then it's like, okay, maybe that's a good time to kind of introduce yourself and, sort of give like an introductory, letter to say like, hey, look, if you need anything, I'm always available. This is the best way to get a hold of me, et cetera, et cetera.
If it's starting to get close to arbitration or mediation or trial, is there something you would want from docs, like not necessarily a full narrative, but just like, hey, just a quick synopsis here to help you, or are you already looking at the notes and the notes should be explaining what's going on?
Ideally, the notes are solid, right?
Yep.
And if the attorney reaches out to you, attorneys should be reaching out to you to talk to you about your notes, talked about the treatment and stuff like that. That's a good time to kind of fill in or add some context, right? I don't necessarily know if you want to be sort of like if you haven't even been told about mediation and you're reaching out to the lawyer to be like, hey, I heard you're mediating, you need any help? Because remember, you want to be the compassionate, objective truth seeker, right? Like, and if you're not the advocate, right? If you're not there trying to help the litigation, right? You're just, you're taking really good notes. They're tied to the evidence. They're tied to the science, right? And you're always available for follow-up. You're always available for questions. Then I think that's kind of best practices.
And I think also, as I mentioned on the site a million times, and I mean this in the best way, like you have to practice as though there's no lawyers or insurance companies. And what I mean by that is I should be doing the exact same thing, whether a patient fell off a slide, whether they hurt themselves, or they were in a crash and have a lawyer. It's the same level of care, right? Because you are being that compassionate. Like, I'm not here to help Tyrone win. That's not my job.
Nope.
My job is not to do that. My job is to say, I examined this patient appropriately. I gave my diagnosis to the best of my ability based on what's expected of me, both guidelines, research, and then from there, and I think that's the frustration for a lot of docs that are watching, the really great docs that do that, the patient has a not Tyrone, and we do all that, and then we end up getting, something bad happens where the attorney settled without telling us. They settled for 10 cents. They sent us a check for 10 cents on the dollar, and they never even reached out to us. And that is a little bit of the frustration where some docs are like, well, I'm just going to treat this patient. I'm not going to reach out to you because that's not my job. My job is just to get him better. Mm-hmm. But then there is an outstanding bill, so should I reach out to try to say, hey, just want to check, is everything going okay? Do you have questions? And it is because we aren't being an advocate. We're just being a provider. But then, so when do you suggest something like that happens, a reach out? Or do we just not?
It's hard, right? Because I think
or how do you
helping Tyrone isn't helpful to Tyrone, right? Like you said, like treating, just having a thorough practice where you're documenting this stuff well to be able to deliver the best treatment to the patient, right? To be able to, if you've been seeing this patient for years, look back in your notes and be able to sort of refresh your recollection about sort of what you discussed on day one, right? And you're being objective and science-based and evidence-based in your approach so that you can give them that type of care, right? And by doing that, you make yourself, it's helpful to a lawsuit because just the quality of your care is up there. Oftentimes it can be more patient-driven, right? So if one of the patients says like, hey, I think it would be really nice if my lawyers sort of understood sort of these conversations that we're having, right? Or hey, I got this mediation coming up and I feel like you really get what's going on with me. I know you're sharing your notes and getting the records and stuff like that, but if you were open to a conversation or something like that. So sometimes I think best practices is you have an attentive lawyer, but if you have an educated patient of, like, look, you're going through all of this, and this is sort of happening parallel to my treatment, and they want you to talk to the lawyer. I think that's a little bit better than you sort of knowing what's going on in the background and trying to insert yourself in litigation. That starts to kind of like, you start to look more like the advocate than the person who's right. Because you're there. You want to see this person get better, and you want to make sure that all of their care is well documented so that you can deliver the best possible care.
Right. So if we could just switch gears for a sec, with your background and how you like to do your due diligence, and then just literally eviscerate like some of these insurance docs, give us some examples of what you've seen and how you've done that, like what they've said. And when you're in court questioning them, like the last trial you had, where you just presented the facts where they didn't. Give us a couple examples of like why that worked. What they did was so transparent, where they just were there to be an advocate for the insurance company and not be a doc. Right. Is there things that like you're like, oh my God, this is so clearly not healthcare wise?
Right. I mean, I think one of the big ones with the insurance doc is just they don't have any sort of duty of actual care to, like, the client, right?
Right.
And they're up there telling, a jury that they should, get much less than what we're, asking for, or nothing at all.
Or they're not hurt.
Right, or they're not hurt. And they have no, like,
ethical obligation
whatsoever, right?
They're not
just
being doctors.
Right. They're just up there, and yeah, I think I did a series, and I feel like I did the same cross for every doctor. It was essentially like, okay, so let me understand this. So you got a box, or a file of my expert's notes and my expert's medical records, all of which you're critiquing right now.
Well, they're not even your experts; they're just treating providers.
Right, the treating providers, right there. Mine is in like my case in chief,
sorry,
right?
Yes.
The case in chief's,
okay.
Stuff. Yeah, not mine. And you're critiquing those, critiquing their opinions, but you're basing it all on their other findings, right? And you're doing it from, your office, looking through papers. And if what you say is wrong, if my client actually doesn't get better, then, no sweat off your brow. Yeah. Like you're just gonna keep on. You're gonna just do the next one.
If this patient, and I said that too. If this patient, and I said that in court, I'm like, look, if I agreed with what the IME said based on all the objective data,
right,
that patient can sue me.
Right.
That's true. If I'm like, you don't like, here's your kyphosis, here's upper cervical instability, should be fine.
Right.
And that person leaves and is not fine,
sure,
and I documented those injuries, they can sue me.
I mean, they can sue. They can leave a bad Google review. They can go tell their friends how bad of a doctor you are. Like these insurance docs have. There's no skin in the game. There's no repercussion.
They don't even need a license,
right? And they're willing to sit up there and say, like, look, I know that you're saying that so and so's future has been completely. The trajectory is completely changed. They're not going to be able to live out their hopes and dreams. And I'm totally fine with the jury coming back and giving them nothing, and them, kind of just withering away and just, and I'm totally fine, with, that being a potential outcome here, because there's not going to be any blowback on me. I have no ethical obligation to this person, right? And
I think get them to say that.
Oh yeah.
Okay, so how can any of these docs get in touch with you?
Pretty easy to get in touch with. TyroneGlover.com.
Oh, super easy.
All of my information is right there on the website.
Will you help docs and their clients outside of Colorado in certain cases?
Yeah. In certain cases, I definitely will be available.
So regardless of where you are, Tyrone may be able to help your clients, so you could always reach out to them to see, like, you get a patient that comes in that is unrepresented, where a lot of us do. In fact, I want the majority of you to have patients that are coming. Like, I don't want, I'll take some referrals from Tyrone, but I don't want Tyrone's referrals. Most of the time, they'll have other providers and chiropractors. I want the ones that come in They were just in a crash, and I'm like, I want to try to get them to these people. I know that sounds crazy, where a lot of people are like, how do we work with these firms so they can send me a ton of cases? He's a boutique firm. He takes these cases to trial and fights compared to taking 300 cases and getting them through. So I want my patient to have the best outcomes in terms of their health care. And if an insurance company is really fighting them, which a lot of times they do, I want to make sure they get to him. So if you have a patient that comes in that isn't represented, or maybe they are represented and they're not happy, maybe reach out to Tyrone. The amount that I've learned from this guy, just with who he is and his grit, how you are as a father, talking to you about with your kids, and how you've just protected so many people with their rights and with getting health care. I mean, it's awesome. And off camera, I've said this a bunch, like just watching you fight and the jiu-jitsu and you teaching me jiu-jitsu. And then again, you never hurt me. It was like, I was like a ball of yarn to a cat, which was amazing. And it does make you stronger and it gets you learned. But I think you've taken that into your law practice with representing hurt people. And we talked about that in the beginning as a good, in a sense, wrap up, where you don't just have one game. You're educated, you understand these injuries, you understand what's happening on the outside, and you don't have this script where you're like, okay, this works for 10% of the people, and then the other 80 or whatever, we'll just do this.
Right.
Everyone is different. So a script doesn't totally work because everyone is different. So you have such, you have your jiu-jitsu, you have your wrestling, you have your Muay Thai, you have your cardio, all that, and that's how you represent our patients and these docs and handle this, and that's really awesome, man.
The difference between your patient getting, and you probably know this for, purposes of just helping them get better, but like if you're talking about also wanting to be, do right by them in the context of them pursuing justice, right? Really the kind of devil is in the sort of boring, nuanced, middling details, right? It's the person that goes out and runs those 6 miles, as opposed to the person who gets told, oh no, I can get the same benefits by doing like some 20-minute hit something, you know what I mean?
Right.
It's the people that just like grind out those detailed, solid notes that, read the entire, journal article instead of just sort of the abstract or some summary in some form, right? It's the people that do the sort of, it's the jockos that are in every day at 5:30 a.m. It's the Floyd Mayweathers that are running, that's the stuff that I think ultimately makes the difference when you get into the deep water, right? And so if your fundamentals, if your foundation are really, really tight, and they're tight from day one, that's how I think you can serve your patients well, not only as a provider, but as, a team member in our pursuit for justice. Like, I remember when I decided to go to law school, I was coming back from a fight in Japan with Pride, and I sort of thought to myself, I was like, how many more times can I get like my hand raised and it sort of will feel the same, right? Like, and now I feel like I can sort of be this person in the corner of somebody who is at probably the lowest point in their life by no fault of their own, and they're staring up at some of the most magnanimous, juggernaut companies we've had in the history of our world, right? And that's what they're up against. And if I can help them get their hand raised, I don't know. That's that's a feeling that I don't know if I'm ever going to get tired of. They're going to have to drag me out of the courtroom. And I know there's some old school cats who I'm like, okay, there's ones that I can say, okay, they step back at the right time. I'll step back at the right time. But
do something else.
Yeah, my partners are going to have to tell me. It's like, all right,
it's time to go. Well, and again, this is what I've driven home on this site for anyone watching is exactly, and I've probably gotten it. I know I've gotten it from my dad, who's a grinder, and being privileged to be around people like this through my career, through jiu-jitsu. It's a grind. And the whole point of this site is it's not just macros. It's not a script. You have to use the site. You have to take the time to listen to the articles and the videos, to read the articles that are on there so you know it. It's not just like, oh, I know what a Kimura is. And if you do this, it does that. But if you've never done it, you don't know how to do it. You don't know what a Kimura is. It's the grind. It's the
Yeah.
getting out there and doing the work. And I've had a couple clients like, oh, I'm going to cancel the site because I'm just not using it. You're like, you're not using constant information and knowledge to make yourself better. It's all it's about. Listen to this paper. Read this paper that's on here. See how it relates to your patient. And then you take that information to educate your patient and make sure that your notes have some of it in there to reflect it. So when someone says, here's this macro, though most of those docs that just use macros, if you ask them about that paper, they don't know. That's no help. Know what it means. Hey doc, here's a reference you put in your notes about when their head is turned. You should know why that's a problem. Because you read it, you took the time, you ran the 6 miles, you went into the gym and you trained as a white or a blue belt with a black belt like this and learned and realized that that pain and that suffering was actually fun because you're like, I could get close to that. I'm not going to say I could get like that, but you could get close to that. And then the next thing you know, when I started these black belts that I was like, there's nothing I can do. And then the next thing you know, you're like, I know why that's happening.
Yeah.
And the next thing you know, he's like, I actually shut that down.
Yeah.
And that is the whole point of this site, is to learn, to continue to educate ourselves, but you have to put in the time and grind so that when you have a patient that needs representation, because they are being beat down by the biggest, most powerful companies we've ever seen, and then they go to someone like Tyrone who's going to be like, hey, we're going to represent what you're saying, but then your notes didn't say anything. And if I ask you about this, how come you can't answer? Learn this. And then it goes to Tyrone, and Tyrone's like, yeah, I've spent time looking at this. I know this. We have a really great case, not because you used value drivers, but because this is the right thing. This is what the science shows. This is what the education shows. And we reflected that to the attorneys. That's all I've been trying to teach for the last however many years or whatever, and trying to treat on patients.
Yeah. And if you embrace the grind, if you embrace that deep work, that nuanced work, then that's when you get to have fun, because you just know, you've documented it well. You've documented it well. Like, I know your notes. I know the file cold.
Yep.
You know what I mean? I can, if you get beat up on cross, I can pluck that medical record right out of the binder without even sort of having to look, just knowing where it is, and rehabilitate you on redirect. When you know it cold, then that's when you can feel like, those, sort of the duos almost, like the famous, like the Stockton and Malones, like the people that seem like they were just on like the same wavelength because it's like, I know I know you've documented your file well. I know your file cold. Everything's there. We're gonna put you up as a witness. Your direct is gonna be good. We're not gonna focus on you trying to explain your notes. We're gonna focus on connecting with the jury, telling our client, your patient's story, right? Being present, right? They don't want to, they're giving up like a week or 2 weeks of their whole life. They don't want to see some played movie. They don't want you to just press play on some script that you've already hashed out a million times. They want to see you, interacting. They want to see you back and forth. They want to see you, talking to the jury, right? And just knowing things cold and embracing that grind on both sides makes for that, like, I don't know, it's just a really cool flow state that you can get into with the testimony.
Yeah, I mean, I guess, and both sides need the grinders.
Yeah.
They need the people, they need the docs that put in the time to learn the information and put it down, and we need the attorneys that are grinding too, that are also taking the time to learn this and understand and reach out. Mm-hmm. And that's when, I always believe... And
who have taken the time to grind on the skill set that they're bringing to the table, right? Like the docs, you've learned how to provide, treatment, how to, help your patients get better, and I feel like there's such a grind just to get up to that point as a doctor. And I don't necessarily know that law school does that for lawyers, right? No, you can graduate law school never having set foot in a courtroom or done a direct or an opening statement, and you can hang a shingle and start up a PI litigation firm, right? So you want somebody that not only knows your facts, right, and your report's cold, but they've gotten the reps in on actually deposing witnesses, trying cases, putting together cohesive theories of justice, right? So they got to show up and have that skill set on top of knowing your file cold.
Would you, with that being said, would you be offended if some doc was like, hey, I heard about you, I just have a couple questions, like, have you ever been to court? Would that be offensive?
Like if the doc asked me if I...
Yeah, like, hey, I want to send you a patient, but have you ever tried a case? And
No.
the only reason I'm wondering is, like, if some of these docs, we have, like, patients, they have an attorney, we don't know the attorney, we ask, and then that attorney's like, oh, I've been an attorney for 32 years. Have you ever tried a personal injury case? And they're like, no. That you don't find that would be an offensive question? I don't think it would. Well,
I would not be offended. I'd be a little bit like, you haven't been to my... Because if you go to my website, it's very apparent that I've tried a lot of cases and tried, I think we'll probably have one of the largest verdicts in the state
Colorado,
in 2023.
Right.
So, but aside from them not doing their due diligence, let's say that I maybe didn't have that readily available online, no, I would not be. I've had people be like, how many of these have you tried?
But most legal, I think most law, when you look, they have settlements, but they don't talk that they've been to trial, because a lot haven't.
Yeah.
So do you think, again, you can't speak for everyone, but do you think if a doc called the law office and asked that, would that be bad for him? I don't think it would be, but
I mean,
it seems like it's a good question that we should know, because we're like, all right, if this person never goes, we know what the outcome may be, and this might not be the best outcome that we want.
Right. I mean, you don't necessarily... I don't know if you necessarily... Because you don't want to have this like sort of coordinated, between the doc and the litigator, right? If you're thinking about like, hey, I don't necessarily have a patient right now, but I do want to make sure that when I have a patient and they're entertaining, trying to get the insurance company to do what they're supposed to, that I have some sort of trusted, sort of legal counsel that I feel okay sending them to. Right. Then I think it's kind of a thing where it's like, look, hey, my name is so-and-so, I don't have anything for you right now, but I just have a couple questions, because if I do get somebody, I'm considering, sending them your way. Then I think that that's like a better way to sort of do it than to sort of be like, hey, I'm sending you Joe Smith, and I have some questions about your prowess as a lawyer, right? Because then I feel like that's a little more important. But if you're like, hey, like so for me, example, if you're like, oh, I know, I kind of like what I'm seeing, and maybe we can have a virtual or in-person coffee or something like that, and kind of see if if I can get a better sort of sense and impression. I think that that's fine. And I think fair questions of how many of these have you done? What is your sort of strategy and approach? How many of these are in your office at any given time? I think that that's just sort of knowing, who you similar to us. Like if we want to provide some names of options for our clients, we want to know where we're sending them and sort of what they're going to be getting. And I think it's a fair game.
This was obviously super informative, and again, I super appreciate your time. I appreciate you as a person, you as one of my coaches, you as a lot. Amazing.
Yeah, as one of your patients over the years.
As one of my patients. I couldn't say that because of HIPAA.
Yeah, but I'm saying it, and I'm waving, and I'm waving. It's my HIPAA right.
That's right.
When I was fighting, I would go to you as a provider. You always provide excellent care.
I appreciate that. He's also an amazing fly fisherman, which is...
I don't know about that, but...
He is, man. And
this guy caught rainbows on the arc. Like, who catches rainbows on the arc?
But the great thing with Tyrone is I've never... you have someone that is so explosive and so athletic, and then also so calm and like focused on certain things mentally, and he takes that also into fly fishing, where I'm like, dude, you're still tying that up, and he's just trying to figure it out, where I may lose a little bit of patience before I'm like, I'm gonna go try over here, and Tyrone will be there for an hour and he'll come back, I pulled 5 out of there, and and he'll spend his time, and that's the way he is in practice and how he will represent your clients. And he's just a great resource. Even if you're not in Colorado, he's a great resource to reach out to and to ask, and he's only going to make you better as a doc, and he's here to help your patients. So thank you all so much for logging in, and again, thank you so much for your time. And we're going to get to the Q&A.